like I was saying, this should be the form you'll start using for offers as of November 1. You know, this class today is not going to talk about any other form other than the FAR bar as is. You know, there is a repair clause contract that is sometimes used. I don't see it much, and you know, it's a totally different contract. So we're not going to address that. I don't even think that that's been revised. We're only talking about the FAR bar as is 2021, which again, you'll see in the bottom left of the form, whether you're a listing agent receiving contracts, an agent on behalf of a buyer preparing one, you should absolutely be sure from Friday or Saturday on the 1st, I guess Monday, that the form has changed. All right. So with that said, I'm going to, Ariel, is this the first page of the PowerPoint? If so, can you go to the next screen? Okay, so here's an overview and these materials were furnished. I went to a real property update on this just a week ago or so. So we're all really learning it together. But here's an overview of the paragraphs and the riders that changed. You can just have, you know, you'll have the materials to refer back to. Next one, please, Ariel. And here's a little intro, which I think I said now off video or off recording, but I'll go into again. It's really, you know, for me, it's kind of personal. I'm very involved in the real property section of the bar. We call it Reptile. It's the real property, probate, and trust law section, because real property, which we call dirt law, intersects with probate law, which we call death law. The dirt and the death lawyers are one super huge section of the Florida bar. That's half of the FAR bar, the other half is the FAR. So what I was saying is that I've been seeing updates, and I would imagine if you're involved with FAR, you've been seeing updates, you've been seeing things that members, you know, just street level people like us, you know, doing deals are coming up with. We go to our trade group intersects with the other trade group, and we over time figure out which, if any, provisions of the FAR bar should be changed. And it's usually updated every 2 years. This has been 4 years. So, you know, we have a lot of changes to cover. Like I said, you know, the last one was the FAR bar 5, which was promulgated in 17. And now it's going to be the FAR bar 6 that you'll see starting Monday, the 1st. Notable changes, personal property, which I think is the next screen we'll get right into. Financing has changed tremendously. Notice, time, force majeure. There's a few others, but we're going to go through all of the changes. And then, like I said, I mean, with 50 something people, it is probably a little much to kind of just, go all over the place because it's a lot of materials, but I will definitely be checking the chat every couple minutes, and I'll try to answer questions or address them simultaneous to how we're going. So next screen, please, Ariel. Okay, next screen. Okay, so interestingly, personal property is always a section of the contract that really needs attention right away. As an agent, you should be super clear on what, if anything, currently, and it still is included and what's excluded. So, we fight about these things sometimes, at closings, this was included, that wasn't, 100%, you're best off being clear with your buyer or your seller what they expect that they'll be getting when they buy, what they expect to be taking when they sell. All right, that should be clear, that should be communicated and put in the contract, because there will be disputes later. So personal property now includes a few extra things. You'll see it. Thermostats, okay, probably would have been given. Doorbells, interesting now, with rings all over, I don't think many people would consider taking their Ring cameras, but, now it's pretty clear that if it's the Ring doorbell, it's staying. Television wall mounts, mounting hardware, mailbox keys, excuse me, I would think for condos, storm protection items and hardware, sometimes probably the lawyer side, the bar side of the FAR bar, we like to keep things a little generic. We don't want to legislate every single thing, so we end up compromising with words like items. Intercoms have been deleted, I guess just because they're kind of obsolete, and personal property that has no contributory value. So, this is a page 1 item. These are things that, you as agents who are in homes, condos, single family home, more single family home, you should just know, these are default items. These are just default items now. There's no, you're still going to put in there inclusions, and you're still going to put in exclusions, but these are changes to default. Next page, and I will check the chat real quick. Yeah, doorbells like, yeah, yes, exactly, Oscar. Doorbells like Ring and thermostats, yes. And then George A, would a distinction of hardware, I don't understand what a distinction of hardware, if it exists, means.
A lot of times you might have shutters, but they don't have the keys, or they don't have, there's parts missing.
Yeah, I mean, technically they're obligated to give them. Now, if you go back 1 page, there is some language there. Ariel, if you can move back to, yes. It says in the contract, yeah, here you go. Georgia, I've seen this once or twice before. If you look at the first 2 sentences of personal property, it says, unless excluded, the following which are owned by seller and existing on the property as of the date of the offer are included. So I've always kind of been of the position, if this is an as-is contract. So if there's hardware related to hurricane shutters or whatnot, technically, contractually, it's going to be what's there. All right, the seller's not going to be expected to go out and buy additional equipment that isn't there. So I think that responds, hopefully. If not, let me know. And this is, still Zoom, so it's kind of weird, but let's just keep moving on otherwise. So next screen. All right, this is super interesting. And this is really something that, is kind of chicken and the egg. So now we've changed the definition of collected funds. Collected, still means wire transfer or cashier's check, right? I mean, collected means that me as a title agent, I don't have to wait for collection. I have immediately available and collected funds, bank funds, not buyer funds, right? I'm not taking a personal check like I do for escrow deposit that has time for clearance. I'm getting collected funds, which means the bank certifies those funds as their funds and ready to move. So now it ties into the next page, please, Ariel.
Well, Michael, we do have some questions in the chat.
All right.
In reference to washer and dryer.
Oh, okay. So the washer dryer has now been explicitly excluded. If you can go back a page, is there a way, Ariel, that I can that you can give me the this way I don't have to keep asking you, and we won't have quite the delay. Can you give me control as well, or is it just for you?
Of the PowerPoint, it would only be me.
Okay, so fine, perfect. I'm sorry to keep bothering you with the back and forth.
We're good.
What would one of the questions I know was, what would be an example of no contributory value? I don't know. Again, these are things that lawyers put in there to kind of allow deals to go forward. I mean, that would be just a fact question. You guys would know better than me, because what has value to one doesn't to others. So there's always going to be clauses that lawyers are ultimately going to decide need to be in there for protection or defense. I have no idea. I mean, it's kind of like, a Supreme Court justice once said, how you define pornography, you know it when you see it. So I would just go with that. You know it when you see it if it's crap, no contributory value, i.e. crap, kind of just go with it. I can't tell you much more than that, because not everything is ever going to be agreed to, but I will say and stress, use the inclusions and the exclusions if you're not sure either way. Washer dryer, if you go back one, Ariel, I may have, I think it was in the PowerPoint, the washer dryer is now excluded. It, in fact, never has been included, which is an oddity, but it hasn't changed. Washer dryer, if you're not aware, is not included in default personal property included in a sale. So if you're a buyer, you need to include it. If you're a seller, it's assumed that you're taking it with you, as crazy as it is. That is the way the contract has always been. Okay, I think I'm caught up on questions, so let's move on. Ariel, just tell me if there's something that I've missed, and we'll keep moving. So next page. Okay, this is super interesting and ties into the collected funds. I don't know that this will change in practice, but it's now contractually clear that a closing happens, a closing has occurred when the closing agent, me, has all the paper for money. I tell everyone that closings are for a buyer, money for paper, or a seller, paper for money. That's all it ever is, right? The paper and the money come to me together like Volcron, and then everything happens. So this contract is defining when closing occurs, and it's what many lawyers believe to be the case. It is not technically, contractually, when the seller receives their money, okay? It is technically, contractually, not practically, but technically and contractually, when the closing agent has the money in the paper. Now, I'm sure there's already questions, am I to release keys? What if my seller says they're not to release keys until the money gets there? What if my seller's attorney, which I've always done, says no money, no keys? You're going to still do that, okay? You can still do that. I'm not here talking to a computer screen telling you that you shouldn't do that. I'm just telling you what the contract says now to make clear, all right? So, Sandra, so it means keys are released when that. So no, I'm not saying that there's not a need to wait for seller confirmation, because I'm well aware, representing sellers, that they don't really care that the closing agent has the money in the paper. They want their money. I'm not. I repeat, I am not telling you that you should change, and I'm not telling you I'm going to change from what my sellers are going to do. I'm just telling you what the contract says. Generally, you're talking a matter of minutes to hours at most between when the closing occurs per the contract. I have all the money, I have all the paper, I have funding approval, to when the seller gets their money, right? I mean, most attorneys, most title companies should be able to wire in real time. I can wire in real time. The seller, all goes well, will get their money, within 2 to 3 minutes. So I'm not telling you I'm going to change my course of action, or you should. I'm just telling you what the contract now says. If push came to shove and 2 lawyers were fighting, or 2 brokers were fighting, or a lawyer and a broker, or a seller and a closing agent, this is what the contract says. But by the time anyone would ever get anywhere in following up on the dispute, unless the shit's really hitting the fan, the seller will have their money, okay? I'm just telling you what the contract, contracts are very theoretical. They're written in a room, with negotiation, with back and forths. What happens on the street, we all know is different. Let me see these comments. Oscar, I see the buyer's attorney arguing for the keys and not waiting for seller to get keys. Do we need to put in additional terms the keys? That's a good question. That's a really good question and a good point. You can absolutely handle it in an addendum or additional terms. There's nothing wrong with that. 100%. You can say, Oscar, if you have the listing, you can say keys will be released to buyer upon seller confirming receipt of funds. That's fine. They're coming in fast. Okay, when working with sellers, shall we ask them when they would like to give? Yeah, I would do exactly what Oscar asked about. If you're a listing agent and you want to be clear and you want to really seem, to be advocating, because really all we're doing is guarding against that small, percentage, but real, of times where there may be funding issues, on wires. We have OFAC, we have, all kinds of banking issues. So yeah, Karen, what does it mean all closing docs delivered? That's very easy. If you're a seller, it's all the seller's docs and requirements under the title commitment. And when it's a buyer, it means loan docs primarily and settlement statement signed. So the standard, any closing docs, would be on the seller side title or conveyance docs, and on the buyer side loan docs, and on both sides settlement statement. I caught up on the chat.
We have another question up further up in the chat. What about foreign nationals? No real time there.
Why? I don't know what that means. No real time there. I mean, why would that be different? Wires would still come in, documents would still come in. That shouldn't be. That shouldn't change things either way, as far as I'm concerned. All right, onward.
They're referring to time difference and weekends with foreign nationals.
That's not. There's nothing that's changed in that regard. There's nothing. There's nothing has changed in that regard. I mean, we can, the contract, we'll get to a point where it talks about days, but yeah, that's not really such an issue. Next page. Okay, good. All right, this is a quick one. I don't think we'll have that much here. CFPB is the Consumer Financial Protection Bureau. I don't know if Al or anyone mortgage-wise is on here, but that is the now 10-year government body that was created after the mortgage crash to govern mortgages and closing documents, and when borrowers see the settlement statement or now closing disclosure. So this only applies if there's a mortgage, and only applies, as it says, in the event closing funds from the lender aren't available on closing date due to disclosure requirements. It's gone from 10 to 7, I'm sorry. And it's only applicable, the extension for a buyer, if the loan's been obtained, the underwriter's complete, and the closing needs to be extended because there's not enough time for disclosure. So I think most people are kind of familiar with lender disclosure now. If you're not, I'll do a 10-second delay, put it in the chat. But otherwise, this is just kind of a minor change to the contract that's been in existence. Okay, good. I think we're good. Next page, please, Ariel. Okay, this is an interesting one. This is very, day-to-day important. So assignability is much more legal, but because most agents are non-attorneys, because most agents handle the execution and negotiation of contracts, I always try to reiterate to agents that these are, heavy-duty legal documents, all right? So this is one of the heavy-duty legal provisions that is super short and sweet. But what's changed, first of all, is if the box isn't if the box isn't checked on assignability, then it now defaults to not assignable. That's a big deal. That's a big deal. There are many times where I'm sure you see or put in that it'll be Michael Tobin and or assigns. It'll be 108 Biscayne LLC and or assigns. That's very important. So now when you're representing a buyer, I would either write that language in because, and the reason it's important and the reason it's legal is because how we have the buyer's name on the contract is who has the right to take title to the property. And now we're talking the ultimate important legality of how title is owned. It's how title is sold, it's how it's mortgaged, it's how it's leased, and it's how it's devised on death. So how title is taken is how it's on the contract. It's super easy when it was may assign and thereby be released, or may assign but not be released, or the and or assigns up top, that if necessary for estate planning purposes, to add a spouse, to add a kid, to put it in a company name, that's a super important thing. So now you know, make sure if you're a buyer that you check one of the assignable boxes, or you put up there and or assigns. Otherwise, you may have some reckoning to do when the seller tries to hold you up potentially. I will do a kind of 10-second delay, see if there's anything there. No, yeah, like I said, you have to write it in 100%. It won't be clear on the new assignability at all. It's if left blank, it now defaults to unassignable, not assignable. So that's a big deal. You need to check it off as assignable if you're a buyer. There'd really be no reason as a buyer you wouldn't want that checked. It gives you flexibility you will need. George A, if it is written under seller or buyer, it supersedes. If it's written on page 1, and it would only be for buyer. Seller's rights are not assignable. You should never do it as to a seller, but it's only as to a buyer on page 1 and or assigns. Or if you don't do that on page 1, George A, one of the first 2 boxes in paragraph 7 needs to be checked. Okay. All right. I'll just keep doing 10 seconds or so. Give me a chance to breathe and get some water and see if anyone has anything, and then we'll move on. All right.
Excellent. We can play some music if you want to take a break.
Yeah, a little, exactly. I mean, no intermissions here at all. This is like the ultimate one-man show.
So keep going.
All right. All right, let's, I could use an intermission before this one. This is the big change, okay? This is the headliner, right? This is definitely the headliner, always on the contract. It's always the most important thing, or usually, and definitely the headliner on the changes. So let's kind of delve into paragraph 8. I'm definitely going to assume everyone has a working knowledge of this contract and this provision. And I'm going to just kind of assume you understand that and kind of focus on the changes. And then I'm going to go for a while on this, and then I'll check the chat. Okay, so the easy part of the change is that the box we all love, as buyers or sellers, this is a cash transaction with no financing contingency, period. Mic drop, done, boom. All right, no more language like the rest of the 5 lines, okay? The committee's made it crazy simple, very clear. Cash deal, no financing. Still does not mean, never has meant that the buyer can't get financing. Very important you know that, so you don't kind of look silly later. All right, better that you learn it now. It does not mean that the buyer can't get a mortgage. It just means that it's not contingent on getting financing. They can come to closing with a mortgage. The CFPB won't count. That provision we talked about a few minutes ago won't count. No appraisal, nothing will matter. They need to come to closing, be ready to close. It doesn't matter if it's their money or the lender's or uncle or aunts, it doesn't matter. So simplified language there. That's the one we always want. It's not the one we always get. Next page, please. Okay, so this is where the crux of the changes are. If I'm putting you to sleep, wake up just for a few minutes. This is what you came for. Loan approval now includes, loan approval contingency now includes two important components. This is the crux of everything. Your loan approval contingency is for credit and collateral. Your loan approval and your appraisal both must be obtained within the loan approval period. That's the biggest change here, all right? Loan approval and appraisal now must both be completed within the loan approval period. What it used to say before is you had your loan approval period, let's assume 30 days, and you had to get your loan approval. But on the next page, at the top of the next page, it said that even if you've gotten your loan approval within the 30 days, that if it didn't appraise, you can get your money back. No longer says that. So I can't stress enough this as the most important takeaway, that when you're a buyer's agent or a listing agent, you understand that loan approval starting Monday with the FAR Bar 6 includes appraisal within the loan approval, all right? So now here's the new language. I should have said earlier, it's probably obvious by now, but the green are additions, the red are deletions, okay? So contracts contingent, we're going to assume it's 30 days. That, you know, you'll tailor to your situation, but let's go with 30 days. It's contingent upon buyer getting a loan. You'll pick the conventional most of the time, but obviously same as always, FHA, VA, if that's the case, you'll check it. For the purchase of the property. So you can see the inclusions coming up. All right, so nothing's changed in the next sentence or so, but now it says, it makes it clear that loan approval is getting your loan approved and the addition, number 2, buyer's broker. And this is the most interesting language because, you know, there'll be disputes over this. And again, you know, these are negotiations that go on over a long time, but this is the language. Loan approval includes now buyer's mortgage broker or lender having received an appraisal or alternative valuation. Could be a drive-by, could be, pencil search, whatever they say, satisfactory to lender. Already we're gonna, debate what's satisfactory to lender. And again, those are now, we see, only if either is required by the lender, which would be sufficient to meet the terms required for lender to provide financing for buyer and proceed to closing. Wow, those 20 words are gonna change a lot of deals, okay? So let me just go back and kind of try to dissect it a little more. Again, the appraisal has to be done during the loan period. So what it means for you guys is when you're a buyer, the lender may be out of state, they may be local, they may be aware, they may not. They may think, the lenders I'm talking about, that they still have that out under the FAR bar. This is something that the lenders really need to understand because they generally, and usually with good reason, wait on ordering appraisals. And maybe they get credit done first and then the appraisal. Appraisal being a third-party item. I have a lot of third-party vendors I'm dependent on. Depends when I order it, depends how busy they are and when I get it back. But the lenders need to know that loan approval must be within that loan approval period. The brokers need to know, they need to arrange access, and the borrowers need to know. So that's right there, the first major change to financing. And let me see. I don't see anything really in terms of where I am so far. So let's continue to the next page. We're still on financing. Does anyone have any questions, if you want to just put in the chat, in terms of understanding that fundamental point, that appraisal has to now be done during loan approval, whereas before it did not?
I don't know if I have a question so much as a comment. It concerns me a little bit that they're saying alternate valuation. So the idea of a drive-by being okay, or some alternate measure of appraisal, is a little bit scary. And I don't know if it's a dangerous trend moving forward. It worries me a little bit.
It's a good point, and it's a good, it's a good point, Barbie. Appraisals are becoming less automatic for sure. That's what I would say, number one. Appraisals are definitely becoming less automatic. Mortgage lending, has hit, the ultimate big time, right? We have two massive public company lenders in Rocket or Quicket and United Wholesale. So two companies that went public this year raised, billions. So they're changing. Everything about real estate's changed, and we all know that. All of our industries are kind of going to be put on their ear by technology, and this is really just a response to technology. It's a response to market demands of being, quick. It's a response to competitiveness. And all the people on the market and being able to approve faster. So you're right. It is going to be different. And that language is going to be something that sellers' attorneys will hang their hat on in potentially disputing the cancellation on the inability to get financing. Okay. I see chat. Let me put that in.
Somebody asked what happens if it's not done, the appraisal within the loan period. What happens?
Okay.
How can we remedy?
Okay, so you really need to be on top of your game as buyers or sellers. Okay, so if you're a buyer and you want to make, and we'll get to it. You know what? Let me just hold. Well, no, we'll stay on this because this is important. There's more to the financing changes, but we'll stay on the appraisal. So number one. If you're a buyer's agent and you need to make sure that the property appraises to get the financing you need to close the deal, you still use the appraisal contingency. Okay, that appraisal contingency is still there and now more important than ever. Okay, so that's that's number one. Oh, I know. Okay, got it. That's number one. Now, what was the other question, Barbie, in terms of, giving an example? Or Rolando asked, can I give an example of what specifically? Now I'm seeing that I'm a little back.
Sorry.
Who had
Yeah.
Rolando had the question.
Go ahead, Rolando.
Yeah, sorry. My dog got excited.
Hey, exciting stuff.
Sorry about that. The loan approval with the appraisal changes, like how would that play out in a real life scenario? If you could give me like an example of that. I think I'm clear. I would like to hear an example from you if possible.
No problem. All right. So if you're a buyer, again, 30 days is fairly aggressive. Now, if you're a buyer, without adding on the appraisal contingency rider, you better have loan approval and you better have your appraisal done by the 30th day, because whatever time period you have for financing and loan approval now includes the appraisal. Okay, so it's great if you're a listing agent. At the end of 30 days that they're in or they're out. And I'm still going to get to the changes about noticing and things like that. But as a listing agent, you love this. You love this, okay? But as a buyer's agent, this is concerning, okay? This is really concerning as a buyer's agent. And you should really be a little bit scared is not the worst thing as a buyer's agent. And I'd probably put on there the appraisal contingency, and then it'll get taken out by the listing agent. And then you can go to either a little bit more time, go to 40 days, or if nothing else, you make sure to give a CYA to your buyer that this contract and loan approval contingency period includes the appraisal back by that date. And you go to the lender and you say, do you require an appraisal? Yes, okay, please order it early, because I don't know if you know, the contract has changed and now the appraisal must be in by the deadline, okay? Or the lender says, don't worry, we don't require appraisal. You make note of that. That's the most I can really tell you now. You know, again, this is an overview class of the changes to the contract. All I can do is tell you the changes and tell you kind of what I see you guys should do. It'll have to play out. I see a ton of chat, so let me just make sure. Got it, Rolando, good.
One question about if a buyer is doing cash, does he have to disclose that he's getting financing even though there's no contingency for financing?
No, no, he just has to come to the closing table with money. He's got to coordinate it with his attorney and his title agent. And, you know, if there's anything the seller needs to sign, which sometimes happens, sometimes sellers get really weird on a cash deal. When you have a mortgage, they won't sign the CD or something, but no, he doesn't need to disclose it. He just needs to make sure his lender's there at the closing table, you know, with cash.
Brilliant, brilliant, brilliant. I have agents now. We have a lot of you who are negotiating deals back and forth, Michael, that will ultimately probably be executed Monday, Tuesday, the 1st and the 2nd. Should they change to the new contract now, or should they?
No, well, I don't know. Ariel would have to say if it's available. I would say no. I said earlier at the very beginning, maybe before we started recording, the old forms are perfectly enforceable. You know, it's not like they're gonna, you know, now be unenforceable. You know, yeah.
Good.
All right, so, all right, let's keep going back to financing because I'm not done on the changes. Now, okay, so now, the next paragraph, we're on the right page, we're on the next paragraph of the provision. And it says, it just reiterates that loan approval, right, is loan approval and appraisal within the period. And then it reiterates and changes a little bit that situation where you have a condition related to the sale of your property by buyer. Now it says loan approval which requires buyer to sell another property shall not be considered loan approval unless the rider's attached, which is good. So it's not loan approval if the approval says that it's contingent upon the sale of another property. That's been the case. This was just clarified. Okay, so now next page. We're going to get now to, okay, now we're going to get to the keeping informed and the notice peer provisions also on financing as that 30-day deadline approaches. Okay. What I don't think happens enough when you're the seller is you're kept too much in the dark on the status of the loan. I find that too many sellers, listing agents, aren't clear about the seller's right to be kept apprised of the buyer's mortgage loan approval or status. That hasn't changed, although now they've made it even harder on sellers. Not really harder, but now you have to make a written request. That can be an email, that can be, you know, anything in writing. You know, the contract later defines written request as electronic, you know, or you know, old school ways, mail or what. But let's be honest, it's all email. And text would work. Text would work. So now a seller needs to make a written request, which, you know, they always would have done probably in the form of an email. And if so, then the buyer has to keep them advised of the status of loan application. Because remember, loan application is a contractual requirement, and now also important. We'll go to it in the next screen or so. So remember, very important that your buyers make timely loan application. It can kill them down the road in a deposit dispute. All right, so that's it. The seller has, they added as appropriate and allowed, just because probably lawyers. So sellers have to be kept advised. They have to ask for the written request as to what's going on. And that's that. As to the next, we're really going paragraph by paragraph on the financing provision. Next page, please, Ariel. Okay, now we're going to get to the end of the period. All right, it's always been that the buyer has until the end of the loan approval to cancel. All right. And if they didn't cancel, then there was a 3-day period where the seller could cancel. And then if the seller didn't cancel, the buyer was hard on the deal. All right. It's pretty much the same here, except now it says if within the loan approval period, the buyer gets their loan approval, which again now includes appraisal, buyer shall notify seller of same in writing prior to the 30 days, or if buyer's unable to get the loan or unable to get the loan approval more specifically within the 30 days, but they're willing to take the chance and don't want to lose the property, which in the contract language says, but buyer satisfied with buyer's ability to obtain the loan approval and proceed to closing, then buyer shall give notice saying, hey, I didn't get the loan, but I'm going forward anyway. That's to avoid the situation where the buyer's silent and loses the property because the seller cancels. Okay, so next screen. So now we're left with this as a buyer, all right, and just flip it as a seller, you know, for you know what it's worth. But we're really talking about a buyer. If the buyer can't get the loan within the 30 days, which again, not to reiterate too much, but I'm reiterating too much, includes appraisal, they can terminate by written notice to the seller prior to the expiration of the loan approval period. They get their deposit back. However, we've got some major legal language. We now have the language provided that the buyer is not in default. Okay, so let's break now. Let's continue generalities and then we'll track the actual language. If the buyer gives no written notice, the contract proceeds as if it's a cash deal. All right, that assumes the seller hasn't canceled during those 3 days, which the seller, you know, can in a market like this. All right, so you need to be on your game as a buyer and as a seller, just like you always needed to be on your game as a buyer and seller's agent as the 30 days approaches. Let's just track the language quickly. All right, if buyer's unable to get the loan within the loan approval period or can't timely meet the terms of the loan approval after exercising good faith by delivering written notice of termination to the seller, whereupon provided buyer's not in default under the terms of the contract, that's going to be, you know, that's going to be some real fodder for lawyers if they want it to be. Okay. So if they give timely notice and provided they're not in default, the buyer shall be refunded the deposit, thereby releasing the parties from obligations under. Okay, that's a big one. That's a big one, and I see some questions. I'll get to them in a second. If they don't give the notice, okay, then they're hard on the deal and they're proceeding forward with the contract. However, the language that hasn't changed, seller can terminate by delivering written notice of the termination to buyer within 3 days after expiration of loan approval. That happens in upward moving markets, in hot markets like this. Buyer doesn't do what they need to in terms of canceling or now giving notice that they're still going forward, and therefore, but they intend to go forward, they just missed the deadline or didn't think they needed to act, they can have their contract terminated by the seller. It's one of the very few times the seller can legally terminate a contract. All right, let me stop there and check the chat.
Sandra wants to know what other condition in default? Would it be something like them not applying for the association, not applying for the mortgage, maybe not putting their deposit on time? What would be the other default things?
All three of those, Barbie. All three of those. It would be any obligation that the buyer had to undertake in the closing on any kind of time basis. So the three you said are probably the big three: making your deposit on time, making application for a condo, making application for the mortgage, you really hit the big three, you know. So that said, you know, we're attorneys, right? I mean, you know, we're trained to kind of, you know, make arguments and build arguments and defend arguments, and, you know, that's what we do. So there's more in there. I don't really know offhand, you know, that, but anything that, you know, it's just going to give rise. And I know I've spoken, you know, on these calls with David as well. And I think it just kind of lends itself more that, you know, it's going to be difficult, but you need to get those cancellation of contracts, you know, because, and it sucks to send those to a seller because you're basically asking their permission to release escrow. But I really think you need to. And I really think, you know, going back, it puts a premium on the agent because the buyers look into you, even though, you know, they shouldn't, you know, it really, you know, puts it on you guys to stay in touch with the buyer or the lender, you know, keep, you know, like when we open a new file, when we get escrow, when we put our orders in, we do an intro call with the buyer, and I always ask, you know, the status. And you know, for the most part, I find that buyers are really on top of it, but sometimes they're not, and they just kind of assume, oh, I'm going to buy this property, I'm going to get the loan, you know. So yeah, that's that.
That's true. And George asked a brilliant question. So the buyer must notify the seller in writing that they received their commitment so that they're protected from seller withdrawal.
100%, George. That's exactly right. That's 100% right. You must notify, but that hasn't changed, George. That's always been the contract. That's always been the contract. So that has not changed. That specific requirement to send the notice and that 3-day period. That 3-day period, people can get, you know, really in trouble. Yes, if buyer gets loan approval, why would they not proceed? They have to. If they get loan approval, they have no out. They only have an out if they don't get loan approval, Sherry. Jamil, could seller keep the escrow, buyer doesn't? Absolutely. I mean, you know, they don't have the escrow to keep, excuse me, but they can certainly make a claim on escrow, and the escrow agent won't be able to do anything without mutually signed release or a court order. But that's where, you know, the pre-suit mediation provision comes in oftentimes, you know, on these disputes. Okay, let's go. We have one more page on the financing, so we're not even done with the financing. If you can switch pages, Ariel, to the next page. Okay, so here you see that this is the last paragraph of the FAR-BAR mortgage contingency period provision. We haven't changed it structurally. It's just changes within the paragraphs. You'll see it when you see the contract in full. But this specifically excludes, excuse me, appraisal from property-related conditions of loan approval that, if not met, preclude giving the deposit to seller. Okay, so we've changed that. It's still property-related conditions, but not appraisal. Okay, so property-related conditions, you know, could include inability to get insurance because of, you know, code issues, roof issues, permit issues. Litigation with the association is a big one that you know, I use a lot, where, you know, the lender has an issue with the condo estoppel letter or, you know, condo questionnaire that the lender requires. There's litigation with the association, and they won't approve it. That's a property related condition. So even if we've gotten loan approval, even if we've gotten appraisal, we can get out later as a buyer because of property related conditions. The FAR-BAR 5 always included the appraisal as an out. Even if you got loan approval, it no longer does. That, let's see, the problem I always see is that the lender sends a loan approval with conditions. That hasn't changed. No, that hasn't changed, Sandra. And you're going to have to get that loan approval with conditions early and make sure you get those conditions cleared by the 30 days. Otherwise, you can still always get an extension for loan contingency period. But yes, that is a problem. And that's where, look, kudos to you guys, there's 60 people here, learning about this, the lenders need to be aware of this as well. So that's that. Thank you, Plenio. Learn about every day. Lender sends the approval to the seller. That's not a that's the seller's right. I don't know, Sam, if lenders are getting this update. They should for sure. All right, so let's continue on. I'm going to exit out of the chat for now. And next page, Ariel, please. Okay, so I've given you all these thoughts, I think, but if not, I'm going to take 10 seconds, give this summary page a little digestion. And if not, we'll close up on financing, and we still have some other changes, but this is just final thoughts on them.
I love it. I'll read that for those of you who are a little distracted. Buyer's choices.
Okay.
If no loan approval, including the appraisal if required, within the loan approval period, give timely written notice of termination. Deposit will be returned if not in default, using one of the other default measures, right? Not putting your deposit on time and all of that kind of stuff. You must give timely written notice of intent to proceed regardless of loan approval. So no longer is it implied, is that what the way it is, Michael? No longer is it implied that you got approved if you didn't say anything.
Right, correct. It never was implied that you were approved. It was never implied.
Thought that it was.
Well, wait. We're talking again about what George A. was asking.
Yeah.
It's implied you got approved if the seller doesn't cancel. So there's
Correct.
two things. So yes, it's, you need to tell the seller you were approved. It's exactly what George A. put in the chat.
Yeah.
If you want to protect yourself from a seller canceling on you, you
Yep.
need to provide loan approval. But if you don't give any notice and the seller doesn't cancel on you, then it's implied you got the approval, Barbie.
Got you. But in the hottest market of all times, when people are rushing to accept offers and then weeks later they get higher offers, that could be the window that a smart seller and a smart listing agent will use.
Right,
So
right.
don't,
Like George A., if she's got a big deal that she's working on and she's the listing agent, and has the buyer, she's in a tricky situation. She's got to advise the buyer, their rights, the seller, their rights. If you have both sides, whoever you are, George A. or not, you have an issue here because you have differing interests potentially under this provision, this specific provision that George A. asked about, I'm speaking of, the situation where the buyer hasn't given the seller notice in writing that they got their loan and the seller wants out for whatever reason, better deal or change of heart. You need to be sure you understand that your loan approval is going to be used offensively or defensively, okay? That provision is going to be used offensively or defensively, sword or shield, okay?
brilliant, brilliant, brilliant. You're going to have to negotiate the extension of the loan approval period, or you can do nothing and pray. Is that what that means when you say do silence? Do nothing and pray it works out your way.
Or no. Now the contract gives you the third option, which is to give notice that you're still going forward with the deal as the buyer, basically waiving your loan approval contingency, going hard so you don't lose the deal. That's your third option that didn't exist.
Good.
You didn't have that option in the FAR Bar 5 to continue on with the deal at your risk, even though you didn't get loan approval. Now you do.
So you have to show something that's gonna, meaning if they're like,
No,
I'm going through.
you just go back. Ariel, if you can go back a few slides, I'll tell you when to stop. It's going to be at least 2. One more. One more forward. Yeah, the one you were just on. Yeah. Okay. So in sub 3, again, if within loan approval buyer gets their loan, they'll notify the seller in writing, or if buyer's not able to get loan approval within the loan approval period, but buyer satisfied with buyer's ability to obtain loan approval and proceed to closing, buyer gives written notice to seller confirming same being that they're satisfied with their ability to obtain loan approval and ready to proceed to closing. Then they waive their mortgage contingency, and they don't run the risk of the seller canceling on them.
Michael,
Yes.
if I might interject, and you're the expert, so these conditional approvals are subject to change. I mean, you can have conditions 1 minute and then new conditions the next minute. So even if a buyer is willing to proceed based upon the conditions of their appraisal, or I mean of their commitment letter, wouldn't you say like buyer beware, because it can go back into underwriting and new conditions can be applied?
I'm gonna put you on mute because my wife's calling. I'll be right back.
Food for thought, food for anything can happen on live television, my dears.
Okay,
That is
buyer lets them know, actually, yes, we're still moving forward, basically.
Somebody
But the
was
buyer has
asking
to let
about,
them
I'm sorry to interrupt. Somebody was asking me about conditions. So yes, if you're not sure that I mean, I don't often see the lender adding on conditions, but if you're not sure that you can get the conditions that the lenders put in writing on your loan approval satisfied within your 30 days, thank you, then you should extend, because the ability to satisfy those conditions is in the buyer's control and is at their risk. Okay. All right, so I think we're going to close the chapter on the financing changes, but again, that's the headliner, so you know, want to give that definitely its due. So let's continue on, and we'll start going downhill quick on these. Next page. Next page, we did this. Next page. Okay, we did the final thoughts. Okay, so yeah, we talked about this too. The new requirement that the buyer not be in default to claim deposit, we've talked about that. You know, we've also talked about, you know, where the buyer timely cancels, but, you know, what their risks are, that the seller argues the buyer's in default, or that the escrow agent requires a consent to release of deposit from the seller, which is definitely, you know, something that we're going to require now as an escrow agent. It sucks. I mean, it really does, that you need to get that seller to sign, because, you know, I see plenty of instances where the seller does give buyers a hard time, but it's going to have to be the case. So next page, please, Ariel. Okay, this was apparently part of an appellate decision. I'm not aware of it, but that was part of the reason why. I think it's more market, but the Florida Land Title, you know, just cited a case that's not relevant to you guys. Next page. Okay, all right, super minor here, but the closing cost section was amended that the seller would pay the FERPTA withholding and reporting charges. If you deal with a lot of foreign sellers, not foreign buyers, FERPTA only applies to foreign sellers. You'll know that there are submissions required to the IRS for withholding of funds. Any charges related to that now get paid by the seller. Maybe there was some, you know, uncertainty on that. It's been cleared up. Next page. Okay, we've made clear that if the seller has an owner's title policy from when they bought, that they'll furnish a copy to buyer within 5 days of effective date. That's not as relevant anymore. It used to be we really needed a prior title policy as a base to do title work, title updates. The underwriters now, you know, have moved far away from that. It's now more a matter of ordering a product, ordering a commitment, regardless of whether you have a title base. It's still helpful. You know, if a seller says to you or an attorney says to you, can you get the prior policy? It's a bit of an old school, I'll say, you know, just, you know, leftover thing, but, you know, again, some of these changes are big and some are not so much. Also related to title, this is, you know, pretty clear it was, but I guess they felt a need to add. Almost always we check the Miami-Dade Broward provision. We've made it clear now, or the contract now makes it clear that the buyer designates closing agent. We know whoever pays picks. That's exactly what the Miami-Dade Broward provision is. Continue to check that. This is just clarity, really. Let's see, Miguel Castillo. Do the seller's expenses change if they do? No, they do not. Excellent question. They do not. It's just something that, you know, a seller is furnishing to the buyer, really as a courtesy, to be honest, but it has no financial or cost effect. All right, next page, Ariel, please. Okay, so surveys happen to be among the most last minute products that we need or that we get prior to closing. That and condo estoppels. We're always waiting on those two. Surveys are expensive. Also, like me as a title agent, you know, I have a good rapport with my vendors. I feed them a lot of business. So they give me the ability to cancel my files and get refunds. So that's why, you know, I don't have to go to buyers and say, hey, you owe me for, you know, a title search or municipal search. Surveyors, because they're sending out crews, they don't really credit back. So surveys end up getting ordered later in the game. This says that 5 days prior to closing, buyer has to have the property surveyed. So, you know, not anything that really is going to change the world here. All right, let's see the chat. I'm old school too, George A, but you don't need prior title. And definitely, Miguel, I'm all in agreement that old school is still cool. I have teenagers, so I get my fill of new school. Okay, next page. Oh, let me see. 2 more questions. If there's a delay in getting the survey, that may delay the closing. Yeah, and frankly, Plinio, if the buyer's attorney, title company, hasn't ordered the survey and is expecting the surveyor to get there 3 days before closing, that could be a real problem if a seller wanted to make it a problem, okay? So surveys need to be ordered at least 6 days prior to closing, okay? Andre, can sellers
can a seller sell a property to a second buyer if he has not released the first buyer in case the first buyer didn't get approved?
Totally kind of a topic for another matter, much more legal, but I have this situation with a Keller agent. We just finished it. We got it totally done. A Keller agent referred their seller to me. I wasn't representing them in the closing. The agent referred them to me after the buyer defaulted. Sorry, let's put it this way, after the buyer failed to close. The buyer happened to have had an extremely huge deposit up, so we had great leverage as a seller. We tried to negotiate. The property was, of course, worth more at the time of the default by the buyer than it was at the time of contract execution by, I think, 20 grand or so. So the seller, my client, wanted to get more money. We defaulted the buyer. We made a claim on escrow, and we gave the buyer a chance to meet the terms of another contract we got. And all this time I'm explaining to the seller, hey, you may want to go with the buyer, you know, because we won't have a problem with them, you know, if they'll match the number. The seller didn't want to go with that buyer, didn't trust them, went with the other buyer. Now, to answer your question, Andre, And this is always the risk. The answer is yes, but this buyer who defaulted and had a big escrow and wanted the property and was upset that the seller wouldn't give them the property, even at the higher price they were willing to match, got an attorney and filed something in the public records. They called it a notice of interest in real property. So my client signed the contract with the second buyer, title came up with this, and we were able to negotiate without going to mediation. We had mediation scheduled the next week, but we were able to quickly negotiate a release. We ended up getting a good portion of the deposit, released the rest to the buyer, and the buyer terminated that interest they had filed. So the seller can sell, but there's risks going forward. The second buyer may have some concerns. The first buyer may do something squirrely. So, these are definite legal waters that, you don't want to be navigating without your clients having good legal representation. Okay, out of the chat and into the PowerPoint. Okay, this is not a big one, really will rarely come up, but this is for those special assessments, not condo special assessments, but public body special assessments. This would be non-ad valorem assessments. And now it's clear that if they're not prepayable, then the seller doesn't have to prepay them. They're generally going to be government charges that would be ongoing, not anything to really give much concern to. Next screen.
Excuse me, does that apply to wide green?
No, it doesn't apply to wide green. Good question. Was that George A?
Mhm.
Okay. No, wide green is basically a second mortgage, so that'll come up on title. They'll have to clear their wide green loan. Wide green loans are not assumable.
Got you. Andre asked why a seller wouldn't release a first buyer if he got more money from the second and the first one didn't default.
This seller, good question. This seller had damages. They felt they had been damaged. They had moved out early. They had been in a hotel, and they wanted to be compensated for that. And they were entitled to liquidated damages under the contract. They don't have to prove actual damages or consequential damages. They took an aggressive position, which their contract allowed. Okay. Open and expired permits. Water break.
I love it. Open and expired permit. I'm just going to ask this question out there before
okay.
somebody else does. Is this going to take away our need to put that seller shall resolve all open and permits prior to closing? This will not resolve that. Okay.
No, you absolutely, Barbie, must put that in when you're the buyer. Okay. When you're the seller, it's not as important. You must still put in when you're a buyer in special terms. Seller shall close all open and expired permit, cure any code violations, all prior to closing. All this says is disclosure-wise, this is only the disclosure, that the seller doesn't need to disclose anymore of permits. This is super technical, okay? This 55379 I was involved with as well. Because it's really the real property section of the bar, I have to kind of toot our horn, that convinces the Florida legislature to change laws related to real property, which there are hundreds of. So what happened was 3-4 years ago, 55379 was created to allow for a statutory provision to close open and expired permits through a mechanism. Old ones that couldn't get closed anymore because they were too old. So what this change does, and this is something realtors should understand, but not get too in the weeds on. But what this does is this says, if you've closed an open or expired permit through this statutory procedure, you no longer need to disclose them.
Huh.
Okay. So the takeaway for this is there is a statutory procedure for closing long dormant open permits where you can't find the contractor anymore. There's a whole provision under 55379. That's the takeaway. And that if you've done that, disposed of them through 553, you don't need to disclose to your buyer. All right, next paragraph. Next page, please. I'm not even going to really deal with this. This is for the repair contract. The Florida Land Title had this included, but this is, again, I don't want to even review this because we're not really ever going to use the repair contract, the FAR bar repair. So let's switch out of this because this isn't applicable to the FAR bar as is, which is really what we're highlighting. Okay, so we're going to talk about time now. One thing lawyers really, can't get over, maybe agents as well, is nowhere in this 12-page contract is it defined when the day ends. Okay, there's been this long debate. Is it 5 p.m. or midnight? So I just default to 5 p.m. because it's not clear. So, time is still of the essence. Probably the biggest takeaway, every date matters. Every date can be a default situation. And then it says, it clarifies national legal public holidays. I guess there may have been, a dispute as to, 1 or 2, I don't know if Columbus Day or whatever day that is, but if it falls on a national legal public holiday, then it rolls over to the next calendar day, which is not a Saturday, Sunday. All right, that's all you need there. And then again, they've kind of taken out that 5 p.m. date on the next business date. So the Florida Land Title Association kind of says, well, when, query, question, does this answer when the day ends? I've had a lot of people, a lot of clients, say, well, what time? I can't decide. I can't decide what time. So I'm still going to go with 5 p.m. I don't think that, but I do think that if somebody gave me notice, I probably am going to continue to tell my clients who are giving notice to assume 5 p.m. and tell my clients who are expecting notice that they can give till the end of the day, because it's unclear and we're not going to litigate over 7 hours. Okay, so next page, and I will check the chat. Oh, okay, that's to you, Barbie. Okay, force majeure. COVID definitely has made force majeure kind of an also ran for contract provisions to a starter, a first stringer. So the FAR Bar Committee has edited what constitutes force majeure. Force majeure, for those of you who don't know and care, is forces beyond control. That is a standard contract defense to performance. That, hey, I couldn't do it. I literally couldn't do it if I wanted. So force majeure now gives, I think it's the same, 7 days after the force majeure event no longer exists and prevents performance. So it gives up to a 7-day delay after that event. Now that event has always meant hurricanes, which is the big one. I've had a number of things come up, after storms or during storms, so hurricanes are always going to be force majeure. Flood, extreme weather, which is a little ambiguous. Earthquake, fire, other acts of God, unusual transportation delays. Happen to be having tons of those for goods, but that's not really going to affect real property. Wars, insurrection, civil unrest, you can see, interestingly, was added given everything that's happened in the country over the last year and a half. Acts of terrorism, government actions, mandates, government shutdowns, epidemics, and pandemics. I think we all understand where that came from. Those are now additional examples of force majeure. civil unrest, and pandemic related. All right. So the force majeure is deemed to have begun on the first day the effect of the force majeure prevented performance and lasts 7 days. Totally going to be a legal standard for a judge or jury to decide ultimately. Be careful if you want to use it as a defense, and also if you see it being used as a defense against you or your client. Okay.
I remember having a conversation, you and I, back in
Yeah.
February, March of 2020, and I asked you, is force majeure a thing now? And you said, no, that's not a thing. And here
Oh,
it is.
really? It
Yeah.
must have been really early on.
Really early in the process.
Because
Amazing.
it became a thing in the 3rd week of March. You know, once the shutdown hit, I had several deals, buyers and sellers wanting to get out. And a lot of those deals canceled with deposit, either refunds or splits. You know, the world was ending, everyone thought. So, but yeah, there were early on, but then the market exploded, and you know, but in March and April, force majeure was really all lawyers could talk about, and I did a Tobin talk about it. So if you're really interested, another shameless plug, go check
There we
out
go.
Tobin talk.
Brilliant.
That's force majeure. Okay, next page. FinCEN is now contractually changed that the buyers clearly need to provide closing agents with essential info to complete FinCEN, photo ID, all the information on the beneficial owners. FinCEN, if you don't know, requires disclosure to the IRS or to the Treasury Department of anyone who buys a property in the name of an LLC over 350K that's cash. Okay, we, unfortunately, the closing agents, title agents, need to then go to the buyer and say, hi, I see you're buying it in this name. I need the driver's license and all the essential documentation the form requires for any beneficial owner to report to the Treasury Department. So just kind of FYI, more for the agents to understand, but for the attorneys and title companies, you know, something important. Next page. I have no idea where we are in terms of, like, you know, everything, but I think we have to be getting close. Okay, so this is talking about prorations and credits. We're always going to prorate taxes, both ad valorem and non-ad valorem, and we're going to now prorate special district assessments, if any. A lot of West Broward cities will have special districts, and they may have annual assessments, and now it's clear that those will be prorated in the year of the closing. So not anything that's going to really, you know, affect that much. Next page. Okay, a pretty legal provision that's in the standard section of the contract, not many changes, but it reiterates that, again, contracts can't be recorded. We talked about this when I told you the example of the file I just recently had. Really, you can't record anything in the public records unless it's founded on an interest in the public record. So buyers can't record on sellers' properties. They're liable for slander of title claims, but it happens. And then we talk about notices that must be in writing, may only be made by mail, fax, email. So texts, interestingly, are not considered. I think I may have misspoke earlier, but texts are not considered legal notices under the contract. Emails are. Okay, so no texts for cancellations of contracts, no texts for notice of you know, going forward with financing like we talked about. no text for important stuff. Okay. All right, next slide, please. Okay, let's talk about some riders. VA rider, it defines what it is. I don't know, you know, I didn't know that it never had, but nothing really here. You know, just a few, seller shall also comply with lender required inspections, presumably in addition to buyer inspections. So next slide. This is not for the as is again, because this is a separate mold inspection. You can put this on the as is, but you generally wouldn't, because a buyer under an as is would normally be required to check for mold as part of their inspection period. But this is a rider that would be for the standard repair clause inspection, generally not for the as is contract. Next slide, I'll check the chats. Oh, thank you. All right, back to cancellation. If it's a fresh contract, I assume no deposits have been made, is an email on behalf of the buyer. Yeah, that an email would be fine for notice under the contract, you know. I recommend that you email more people than less people when you're giving notice. Just I just think it's a really good idea. You know, just in case you send it to one and they say no, you know, they didn't get it. You know, attorneys and brokers both are authorized representatives. I'd include anyone on a cancellation. So yes, you can do it through email. All right. Okay. So I think the next one's going to be post. So pre and post closing occupancy agreements. This is a big one with all agents. You know, definitely something I've talked about multiple times with Keller agents. And that is that you want to be very clear on this form. You can see that the primary change is that the pre-closing agreement is not considered a lease. And that's something that most attorneys understand. And that's because we have a Landlord-Tenant Act in Florida statutes that gives a whole host of rights. And we don't want the buyer who's in the property under a pre-closing occupancy, which really is much more risky than a post-closing. You know, but we don't want them to have the rights of a tenant under the landlord-tenant statute. So that's what the main, really the only change here was, differentiating it from a lease. I will say this, and this is what I've told to a lot of Keller agents. This form doesn't provide for amounts to be withheld by either party as security. That needs to be written in for both sides, excuse me. It doesn't include money that would be held back for security. So that's definitely something agents need to know. I know I've spoken to a bunch of agents on this, you know, over the last, you know, couple years. Be clear when you're negotiating the terms of the pre-closing or the next one, which you can switch to REL if you would, post-closing occupancy agreement. Add that in. I'm a big believer that when you're a buyer, and the post-closing is going to be much more common than the pre-closing, right? Very few people are going to be comfortable, it happens, but very few people are going to be comfortable allowing a buyer to take occupancy before they close. Different with the seller, you know, they've closed. Yes, in theory, you could say there's a risk, but that's why I would tell you to have the seller escrow some money, hold back some money at the closing table. Even if they're staying a short time, you want them to kind of be vested. You want there to be some skin, you know, in that. What's the best way to clarify the held deposit transfer? I would just write in there, you know, that at closing, seller shall escrow or closing agent shall escrow $10,000 from seller's proceeds, $2,500, $20,000, doesn't matter. Figure out the right number until seller has vacated the property in accordance with this provision. I'll just write that But it's got to be negotiated, because I get to closing and I find out I get a pre-closing agreement sent late, and then I represent the buyer and I explain, or the buyer asks, what if they don't move? Well, we got to sue them. Well, it's a lot easier and it's less likely to have to sue someone if they have left 5, 10, 20K on the table for the 2 weeks, the month, whatever. Make it proportionate to how long they're staying, but I definitely would stress that buyers want to hold some money with the escrow agent, of the seller pending their moving out.
Michael,
Yes.
so others can learn from my most recent mistake. This sum of money definitely should be agreed to prior to execution of the contract. I neglected to do that recently and said it would be determined during when they did the occupancy agreement, and there was a discrepancy on what was acceptable, and it created a huge mess. So just saying.
Yeah, totally. And this would be where you'd put it, George, because this is going to be a rider to the contract. So unless, which sometimes happens, you realize the need for the post-closing happens afterwards, then you do this and you can just write it in. But yeah, this would be where you'd put it, as a rider to the contract. Would it be unreasonable to hold that escrow after closing until, well, we're not talking about tenants. We're talking about the seller as a post-closing occupant, not talking about tenants. Okay, let's go to the next page. After post-closing, perfect, okay. All right, we talked about this earlier where the sale of the buyer's property is an express contingency. We have this often. It's difficult to, to kind of, get this, to the seller's satisfaction or agreement because it's just so speculative. But basically this says that the buyer can give notice to the seller if their sale doesn't close and it terminates the contract. But if and it gives a deadline, so you have a drop dead date there, and then if the buyer fails to timely deliver the notice, this is the change, that their deal fell through and they're canceling, that the contingency shall not have any effect, and then they're hard under that. And then it later says that if the buyer's property is under contract at the time that the buyer, so if the buyer's contract is under contract for sale at the time the buyer makes the offer to purchase, the buyer has to give the seller a copy of the contract with now the addition, the third-party ID and purchase price information obliterated, so that the seller can, feel confident and comfortable that it's a real deal. All right, next page. Backup contracts. So not much has changed on this, but if the first contract is terminated and the seller gives written notice of the termination of the first contract to buyer on or before 5, that's been taken out. So does it answer the question of when the day ends? Maybe. Makes it more likely it's the end of the day. But if they give the notice by that date, then they can get out, which really, there's very little change to this from what it was. Next. This is, I haven't seen this yet. I've only seen this on this slide, but it makes sense. It's the seller basically identifying whether they can or can't, after the effective date and before closing, enter into new or renewal seasonal rentals. If you're the buyer, you definitely want the may not, and you want the only with buyer's approval. This is a provision that really is from the FAR commercial, and it's putting the burden now on the seller to get the buyer's approval to extend or enter into leases during the executory period of the contract, from when you sign to when you close. That's what we call the executory period. So this is a provision that's standard in the commercial, but now we have this in there. And basically, the only reason you'd use this is if the seller, you know, if you had a lot, this isn't going to come into play much, I don't think, at all for residential, because we're talking such a short period of time. But, you know, it could come up, and that's why I guess it's in the materials. Next page. PACE disclosures. George A. asked about this. These are called PACE loans, or Y-Green is, I think, the company that George A. mentioned. They're one of the biggest companies. These are green. These are private company loans that have been legislated by the state to allow for, they're kind of like home equity loans for generators, for solar, for, you know, water issues. And they are under this PACE, the Property Assessed Clean Energy Program. And now you have to disclose that the mortgage lender will require a release. I think this was, at least I guess I thought that this was a required disclosure, either from FAR or from the Miami Association. Now it's a FAR bar rider. Next page. I think we're done. So